But don't those questions all assume that Congress was thinking about this problem? I mean, I think one of the things that Justice Barrett pointed out in her prior opinion, and that others have commented on, is that there could be the implication that they were copying language from another framework dealing with prisoners who don't have statutory claims, and that they overlooked the particular questions that you pose in this case.
So Justice Jackson, and with all due respect to that suggestion, in your opinion, Justice Barrett, I think that every indication is to the contrary. If we look to the text, there are specific areas in 2255 where Congress talked about rules more generally, like in the statute of limitations. And then in 2255H, it narrows that to rules of constitutional law. I think that's a pretty good indication that it knew there would be some claims that weren't constitutional ones, but it just talked about constitutional ones in H. I think generally this court assumes that Congress is aware of its precedents. I would think Congress would be aware of an important precedent like Davis.
But let me ask you this then. Why isn't there another why question then that comes from your reading, which is in a situation in which we have H, and H is surely saving some things from elimination as successive petitions, the things it's saving seem to be situations that are very much like this one. They're saying you can bring a second and successive petition if there's newly discovered evidence, or if there's a new rule of constitutional law that's made retroactive and therefore would apply to you. Those two kinds of scenarios in which Congress is making very clear that they wanted people to be able to get past the second or successive bar seem to me to be substantively very similar to what is happening here to Mr. Jones. So my question is, why would Congress have drawn the line to keep Mr. Jones out of the second and successive pass-through, but allowed for these other people to keep going?
So first, as a matter of statutory interpretation, I do think you should be drawing the inference that when Congress has talked about similar things with specificity and then left this one out, that should be given some meaning. You know, in terms of why, I think the best explanation is really twofold. I mean, first, these are really the claims of the most recent vintage. They were not recognized as a basis for post-conviction relief until Davis in 1974. So I could imagine Congress taking a little bit of a last-in, first-out approach when it cut down on claims in AEDPA. I think relatedly, we see throughout AEDPA that Congress just thought that constitutional claims were more important than statutory ones. We see that in certificates of appealability. It allows for appeals of constitutional claims, but not statutory ones.